Welcome back for Module 7, which is all about data governance. So let's take a look at the scenario for this module. All right. Now, when Sophie Chen pastes a case chronology brief into ChatGPT 4.0, she's doing three things simultaneously. She's using an AI system, she's processing personal data under UK GDPR, and she is potentially transmitting privileged communications to an external processor. These three obligations attached to a single action. And at baseline, Halstead Cole has documented none of what Sophie Chen has done. Now we're just going to quickly look down to this table down here below. And the one thing that I just want to highlight is the fifth question on that questionnaire is asking, how does your firm protect client data in AI tools? And this is the key thing that we're going to cover here. Okay, so let's look at these two frameworks. Put in ISO on clause 8.3 side by side with the UK GDPR. Now, law firms don't need two separate registers. All they need is one integrated register that documents each AI system data flow in terms that satisfy both ISO 42001 clause 8.3, which is all about data quality and provenance, and UK GDPR's lawful basis, DPA, overseas transfer, as well as special category safeguards. Now, these two frameworks complement each other rather than duplicate each other. Clause 8.3 refers to UK GDPR rather than recreating its obligations. So, in plain English, ISO 42001 clause 8.3 is the data quality and fitness for purpose clause. It's asking whether the data entering each AI system is appropriate for what the system does, whether its provenance is documented, and whether access and use are controlled. Now, UK GDPR is the lawful basis and protection regime. So it's asking whether processing is lawful, whether the data subject is informed, whether the vendor has a DPA, so that's a data processing agreement, and whether international transfers are covered. A single register documents both, which is what makes the response to Pemberton Capital, their question 5, definitive rather than aspirational. Okay, so let's look at these frameworks side by side. First, you've got the ISO 42001 clause 8.3, and let's see what the standards is required. So, documented data provenance for each AI system, meaning where does the data come from? Next, you have data quality assessment, and this is about whether the data is fit for the AI system's intended use. Then you have data access controls, which is who can submit data to each AI system. Next, you have data lineage. Can the firm trace what data was used to produce the given output? Then you have privacy and security controls. Now, they have to be consistent with all legal obligations. And then finally, you've got retention and deletion procedures for AI processed data. So that is ISO 1 clause 8.3. Now let's look at UK GDPR and the data processing agreement 18. So what does the law require? So first, you've got lawful basis identified for each processing activity, and that's Article 6. Then you have special category data, which is explicit consent or Schedule 1 data processing agreement 2018 condition, and that's Article 9. Then you have data processing agreement with AI vendor if they are a processor, and that's Article 28. Then you have international transfer mechanism if data leaves the UK. Now that's Article 44 and 49. Then you have privacy notice updated to reflect the AI processing. And finally, the DPIA mandatory for high risk processing. Okay, so let's look at the 4 data categories. Now, law firms' AI deployments typically involve 4 categories of data, each with a distinct governance requirement. Most firms have no documented framework for any of them in any AI context. Okay, so let's look at the table. We've got categories, Examples in legal practice, we've got the ISO 42008.3's obligation, and then we've also got the UK GDPR's additional requirement and what the common failures are. All right, so first one, special category. So in terms of an example, health data in personal injury or clinical negligence, immigration status, criminal convictions in defense, religious beliefs in employment. Now, under the clause 8.3, highest data quality and access controls, privacy impact addressed in impact assessment. All right. So for this clause 8.3, there has to be an impact assessment done. And by the way, that has to be done before an AI system is actually used. All right. So an impact assessment is done before anyone uses an AI system for special categories. Now, for the UK GDPR, their additional requirement is explicit consent or Schedule 1 Data Processing Agreement 2018 condition required in addition to Article 6 basis. Now, the DPM mandatory for systematic processing. Now, what are the common failures? So from the research, firms just use, in this case, ChatGPT 4.0 to draft a medical chronology, no Schedule 1 condition documented, and no DPIA conducted. The next category, we've got privileged and confidential. So let's look at the examples. We've got counsel's opinions, or without prejudice correspondence, client instructions, strategy documents. Now, under clause 8.3, data has to be documented. Access restriction to authorized fee earners, vendor data terms review for confidentiality. Okay, so for the UK GDPRs, their additional requirement, it states not personal data if anonymized, but privilege is a separate legal concept not displaced by GDPR compliance. Now, the common failure is privileged documents submitted to AI vendor without checking whether the vendor's terms permit use for model training or logging. So this is not checked, is a common failure. The other category is standard personal data. An example is client names, addresses, financial details, counterparty contact details, witness names. Now, for clause 8.3, the requirements is data minimization for AI use. Submit only what the AI system needs for the specific task. Now, for UK GDPR, Article 6, lawful basis required, privacy notice must cover AI processing and a data processing agreement with vendor if there are a processor. So if the vendor itself is the one that's going to be processing the data, there has to be a data processing agreement with that vendor. Now, the common failure is that full client file usually gets submitted to AI for summarization when only the relevant sections was needed. No data minimization was applied. The final section is matter reference anonymized. So anonymized case facts, deducted documents, fictional scenarios for AI testing. That's the example. Now, for clause 8.3, it requires provenance documented event for anonymized data, re-identification risk assessment. And for UK GDPR, the UK GDPR does not apply to truly anonymous data, but pseudonymized data with key held separately remains personal data. And what are the common failures? Firms believe redacted documents are anonymous, but counterparty names, case numbers, and dates remain. Re-identification is actually possible. So those are the 4 categories. Now let's check out the failure modes. So 5 ways an AI data governance process fails. Okay, so you've got the first one. No AI data governance register exists. So a firm has GDPR records, but has not extended them to cover AI-specific processing. So for ISO 42001, clause 8.3, that requires provenance, lineage, and quality are entirely absent for AI systems. So when it comes to audits, an auditor's findings will be AI processing activities are not documented in the firm's data governance framework. The clause 8.3's obligation is unaddressed, and the UK GDPR's Article 30 record is incomplete for AI processing. Let's look at the next failure, which is no lawful basis documented for AI processing. Now, the ROPA, and that is record of processing activities. So the ROPA may record legitimate interests for general CRM processing, but has not been updated to cover AI-specific processing activities. The lawful basis for submitting client data to ChatGPT 4.0, for example, for any purpose, has not been identified or recorded. Without a documented lawful basis, the processing is unlawful under UK GDPR's Article 6, regardless of any other controls that is in place. So what would be an auditor's findings? No lawful basis recorded for AI processing of client data. Article 6, compliance is not evidenced. So that's the second failure. The next failure, we have vendor data processing agreement not executed or not verified as AI specific. So you will have firms that have a Microsoft Office 365 agreement, but have not confirmed that it covers Copilot's AI processing specifically. OpenAI's enterprise zero data retention terms may be in place, but not documented in the AI management system governance framework. Now, UK GDPR's Article 28 requires a binding contract before personal data is submitted to a processor. This obligation is system specific and AI specific, not satisfied by the firm's general commercial terms. So what would an auditor report? It will say vendor data processing terms for AI components not separately documented. So Article 28's obligations for AI specific processing is unevidenced. Another failure is data minimization discipline for AI use. So when it comes to fee earners, we use the example in this module of Sophie Chen. So fee earners submit entire client files to AI tools when only a specific section was actually needed. No governance exists on what data may be submitted to which system, resulting in systematic oversharing that violates both data minimization, so that's UK GDPR's Article 5, and the ISO 42001's Clause 8.3, which is data access and use requirement. Now, every byte of data submitted beyond what is needed for the task increases the regulatory footprint. Now, what would an auditor report? An auditor will say no data minimization controls applied to AI submissions. Article 5, which is data minimization. So compliance not evidenced for AI processing. Finally, you have the special category data in AI without a Schedule 1. So examples like personal injury, clinical negligence, immigration, and employment matters routinely involve special category data. If a fee earner like Sophie Chen uses ChatGPT 4.0 to draft a medical chronology, the firm is processing health data through an AI system, an activity that requires both an Article 9 condition, of which exists at baseline in the typical firm. The ICO treats this as a Tier 1 complaint risk. So when it comes to an audit, the auditor will say special category data processing via, in this case, ChatGPT, without Article 9 condition. Also, it's without the Schedule 1 Data Processing Agreement of 2018 condition, or the DPI Article 9 and Article 5 obligations. They are all unaddressed. So those are the 5 failures. Okay, so let's look at the systems that Halstead Cole is using. So they're using the ChatGPT API. So we could call that the front end of ChatGPT. And they're submitting personal and privileged data, which is obviously going to OpenAI's servers in the US. Now, this is a high risk because there is no data processing agreement confirmed between Halstead Cole and OpenAI. The next system is Copilot integrated into Word, and Halstead Cole is using this for confidential and personal data. Now, as Microsoft is using EU servers, they are within the EU boundary. However, there is still a medium risk because there is no data processing agreement in place or confirmed via Microsoft's 365 agreement. They're also using Copilot within Outlook, and they're using this for personal and privileged comms. Now, as Microsoft is an EU tenant, however, email context window includes privileged content. This is high risk, and the scope needs to be reviewed. Then it comes to the legal specific AI tool or AI system with Leap AI, and they're using this for personal and metadata. Now, Leap AI is on UK servers, and they have a standard Leap data processing agreement. So this risk is low because there is a data processing agreement that has been confirmed. Then you have the special category. So you have no system currently cleared. You've got the clinical negligence, the immigration matters require a DPIA. You got the data processing agreement before any AI use. Then you have special categories. This applies to all systems. So no system, none of these systems above that we've just spoke about is currently cleared. So what's needed is GDPR and the DPIA requirement. All right, so specific data protection obligations requiring separate instruments. Now let's quickly talk about why zero retention isn't really enough. Now, when it comes to open APIs that offers zero data retention as a contractual term, the firm's data is not used for model training and is not retained after the API session. This is a meaningful protection, yes, but it does not eliminate the UK GDPR's obligations. The data processing is still processed, as in transmitted, held in memory, used to generate the output. That is processing under the UK GDPR's Article 4. So the transfer still occurs. The lawful basis is still required. Zero retention reduces the retention-related risk and the training data risk, but it doesn't displace the requirement for a lawful basis or a data processing agreement and an overseas transfer mechanism. Now, the Reg AI management system data documentation documents all of this, not just the retention status itself. All right, so let's look at the fix. How do we fix this? So what we need to do is build a single control document that satisfies ISO 1001, Clause 8.3, and the ICO's AI data governance requirement simultaneously. It will be structured as a register of data flows, one entry per system, per data category combination. What Halstead Cole needs to do to get this built. Okay, so step one, map the data categories to the systems. So the register uses 4 standard categories. So the special category, privileged and confidential, personal data standard, and matter reference, but allows subcategories where needed. For example, distinguishing health data from criminal conviction data within the special category, as they have different Schedule 1 conditions. So all this means is that based on the different types of information, in the example, you had something relating to health and you had something relating to some sort of criminal crime. There could be others in terms of something relating to probate, for example. This is the next category. Every category that is dealt with needs to have a different Schedule 1 condition. So that's what it means by mapping data categories to systems. Step 2, lawful basis documentation. Right, now for each row, you've got to record the Article 6 lawful basis and where special category data is also involved. Also the Article 9 condition and the Schedule 1 Data Processing Agreement 2018 paragraph. You've got to record this. Where the lawful basis has not yet been determined, the row is marked as pending. The system is not cleared for the data category. A system is not cleared for a data category until a lawful basis has been documented and verified by the CLLP. in this Halstead Cole scenario, that is PRIA. So let's go down to step 3. And this is the vendor data processing agreement confirmation. So for each system acting as a data processor, confirm whether a data processing agreement is in place, what it covers, whether it explicitly addresses AI processing, and whether it includes a sub-processor schedule. Record the data processing agreement date and reference. Now, from systems where the vendor is a data controller in their own right, record the basis for transfer and the privacy notice obligations that follow. Then you have step 3, which is overseas transfer mechanisms. Now, where an AI system processes data outside of the UK, for example, OpenAI's US servers, document the transfer mechanism. Now, the UK Adequacy Regulation, the International Data Transfer Agreement, or binding corporate rules. The zero data retention claim made by some vendors may not remove the transfer obligation. So the transfer still crosses borders even if it's not retained. So the transfer mechanism has to be documented. And again, that's either the UK Adequacy Regulation, the International Data Transfer Agreement, or binding corporate rules. Okay, step 5, data minimization rule per system. So for each AI system, you need to document, or Halstead & Co. need to document what data categories may and may not be submitted. These rules are the operational expression of UK GDPR's Article 5 within the AI governance framework, and they are also the Cl.8.3, data access and use control. They should be specific, so personal data submit only the specific passages relevant to the task. Do not submit full client files. Do not submit special category data without prior CLLP approval and a DPIA in place. Then you have step 6, which is a DPIA triggers and clearance. Now, for any processing that is likely to result in a high risk to individuals, requires a data protection impact assessment before processing begins. In the AI context, this includes systematic processing of special category data, automated decision making with legal or similar significant effects, large-scale processing of personal data by AI systems. Okay, next we're going to look at step 6, which is the DPIA triggers and clearance. So, for any processing that is likely to result in a high risk to individuals, this requires a data protection impact assessment before processing begins. Now, in the AI context, this includes systematic processing of special category data, automated decision making with legal or similar significant effects. This also includes large-scale processing of personal data by the AI systems. The register flags which system and data combined require a DPIA. Itself is completed as a separate document and cross-referenced in the register. Now, like always, I've got a template of this document. So I've got here the AI governance register, and let's quickly just look at the different sections. So section 1, you've got the lawful basis and special category condition reference. And here I've put in some example information. So we've got the basis in terms of consent, contract, legal obligation, public task, and so on. And then their definitions, along with how it falls in line with AI in legal practice, and then its limitations. Section 2 is about the AI governance register itself. So we've got the categories in terms of personal data, privileged data, special categories, and now the lawful basis, the status, the data minimization rule, whether or not a DPIA is required, and obviously the sign-off. Now again, this is just a template with demo data in there so that you can have an idea of how this is filled in. Now, do pay attention to the system ID. So when it comes to the data governance register, this assessment is done for each system that follows each data category. So, for example, this system 001 would be the OpenAI's ChatGPT's API. And you're putting in the register in terms of for personal data, privileged data, special categories, and client matters. And then you would repeat the same for all the other systems. Section 3, you've got the vendor data processing agreement logs. So here again, you've got the different systems. OpenAI, in terms of the vendors itself, OpenAI, Microsoft, and Legal AI, states what the agreement type is. And when that agreement's in place, you would have this section here where you'll put in the reference and the date of when that agreement was completed, what the agreement covers, when the potential renewal date is, and obviously its status. Now you've got a record of the overseas transfer mechanism. So again, we've got the systems, the vendor, but in this case, it's got the processing locations, what the transfer mechanism is, and with that, the mechanism reference and additional notes based on the mechanism. Next, you've got the data protection impact assessment trigger checklist. So here we've got the trigger questions. Does AI system process special category personal data? And you would need to answer whether it's yes or no and add the relevant notes in place. Then you've got the data minimization rules. And this is for the fee earners guidance. So for each system, you're stating what is permitted and what is not permitted, what you must not submit. And then also what needs to be done before submitting. Then finally, you have the history and communication logs with regards to any updates to this actual documentation, which obviously needs to be communicated to all parties, all relevant parties within the firm. So again, this is just a template to give you an idea of what an AI data governance register would actually look like. So please feel free to download and edit if you wish. Back on the module, in the link below, you could get access to this HTML wherein you could test yourself with these quick quiz that I've provided. There's only 3 questions in this module that I've put in there just to test your knowledge. And also I've provided a module completion checklist as you're working through it at your own pace. You could tick off when you feel that you've understood the scenario, understood the 2 frameworks, the data categories and failure modes, and the readiness for the next module, which is module 8. Module 8 closes the operational gap. So with the policy, which we covered in gap 1, the AI system register that we covered in gap 3, and the risk register that we covered in gap 4, as well as the data governance register in gap 5, with all those in place, the final module addresses the human oversight procedure that makes the entire framework work in practice. So the human in the loop document defines what review fee earners must conduct before AI output is used in client work, how the review is recorded, how sampling audits are conducted for lower tier systems, and what happens when a reviewer identifies an error. By the end of Module 8, Halstead Cole will have a complete, defensible AI governance framework and a full set of answers to Pemberton Capital's AI governance questionnaire. So, I look forward to seeing you again in Module 8.